It's Our Story. John Holland, Denver, Colorado.
Back in those days, I would pretty much read anything of interest that was happening anywhere in the law. And we found a case, I think it was Bartels versus Biernat out of Wisconsin, where some brave lawyer had started a case to force public transportation to be accessible. So one day I just called Wade up and I said, I'd like to have a lawsuit in the name of Atlantis brought against Brock Adams and the Secretary of Transportation. And RTD is buying 240 buses that are not even configured to be able to accept lifts. And I think we should sue to enjoin them under Section 504 because we didn't have the ADA, the Rehab Act of 1973, which said that, basically no qualified person be deprived services, including transportation, and to shorten it quite a bit. And so Wade said, well, of course, good idea, but I doubt they'll do it, kind of thing. So we organized and found many major people to explain the technology of lifts, and it sort of was an absurd thing. Government's defense was it wasn't technologically feasible to put lifts on buses, and we brought in the community, we brought in a number of Atlantis clients to testify that what it was like to be, the thesis being that the right to be publicly transported was central and essential to the right to be in the world, and that the system had kept people from being in the world and imprisoned them with confinements that they couldn't escape due to accessibility barriers. And so we didn't see how you could run a public transit system that intentionally excluded disabled in the face of technology that could easily make them run. So RTD, you know how in a good story, the enemy has to have a few weak points. And RTD had a lawyer named Jones who was a good man in his way, despite his role as opposition. And he understood early that we might win the case, and that if they ordered the buses unable to accept to be retrofitted, that it would be an unmitigated disaster. So before we even started the lawsuit, RTD agreed that it would order all of the buses equipped to be designed in such a way as to accept lifts should the order come. That was a big mistake in terms of stopping us, because that 240 buses was coming in with the capacity to be retrofitted. And we hired a guy named Dennis Cannon, and I don't remember where he was from. He was probably from California. He was a major expert on disability rights, disabled guy himself, in a chair, and a huge advocate for bus access and configuration. So we worked on that a lot, and Wade came to court and explained the social order for the judge, who didn't really seem that interested at the beginning, but by the end of the case had tears in his eyes because he'd understood, but then had a failure of nerve which didn't allow him to do the right thing. And he said that he was concerned that if he ordered he agreed they were feasible, which was actually a victory back then. We had people on the moon, but they were arguing they couldn't make the buses accessible, and he found that they could. But he said they didn't have to, because he couldn't say to a moral certainty that they were safe. And if somebody got hurt, then he'd be on his head because he ordered it. And we told him that, that was absurd, but he didn't listen. And I never forget, we came out of that courtroom having lost that round, and Wade had organized, in case there was bad press, So the press was there, and Wade went out and said not until the judges in the North learned, like the old racist judges in the South, that you couldn't keep black people out of society, would he return to the courts, that he was going to take the movement to the streets. And so began the process of demonstrations, leading to the capture of the buses at Colfax and Broadway in midday, causing a traffic crisis, leading to the first arrests of disabled protesters. And the arrests actually, ironically, were only of the able-bodied workers, because the mayor, the city, the chief of police, and the city attorney conspired to not appear as fall guys. I got a reporter who wrote that statement to come into court and testify, and we challenged the constitutionality of arresting the able-bodied assistants while leaving the disabled protesters to sleep in the streets undisturbed, because the police didn't want to appear like fall guys. So they ticketed 20-odd people who they took away in semi-violent fashion. And we went into court and challenged the arrests on equal protection grounds, saying that they were selectively prosecuting and that we really couldn't have a civil disobedience movement if we didn't have the right to be arrested. And until they learned to arrest equally those who were involved, they just weren't going to be able to arrest anybody. So the government lost that case, and all of the charges were tossed after a trial, which was dramatic because we couldn't get people into the courtroom because of the bumps and steps in the way, which didn't seem to bother the judge that much, but he got it. And so and it was a very conservative judge, but he said, hey, it's just unconstitutional. City didn't get it, so a couple more demonstrations later, we had a second case, same ruling. And Wade and I used to say to each other, this is actually pretty important. The right to be arrested for protesting is central to the ability to be taken seriously.
The It's Our Story project is a national effort to make disability history public and accessible. Visit us at www.itsourstory.org or on the It's Our Story project YouTube channel.